rig, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm, new paradigm. United and free. United and free. United and free.
Good morning, ladies and gentlemen. Welcome back again. My humblest thanks for your continued service in this case. As I mentioned yesterday, I'm sorry, was there an issue, Ms. Samaro? Oh, notepads? Are there notepads not in the chairs?
Oh, I suppose she walked out with this.
Okay. All right. As I mentioned at the end of the day yesterday, both the state and the defendant have rested their cases. The attorneys will now have the opportunity, if they wish, to make a closing argument. Please remember that what the attorneys say is not evidence, nor is it your instruction on the law. However, do pay close attention to what they have to say. Their arguments are intended to aid you in understanding this case. Each side will have equal opportunity, but the state is entitled to divide its argument between an opening and a rebuttal after the defendant has given a closing argument. Does the state wish to give a closing argument?
I do, Your Honor.
You may proceed.
Ladies and gentlemen, the brutality and the carnage that Collin Griffith unloaded on his mom on September 8th of 2024 is as real as it gets. First, I'd like to thank you for not only being here, but for your attention. When you came to jury selection, you had no idea what type of case you might encounter. Would it be a petty theft, a DUI? But what you ultimately heard and sat on was a first-degree murder case with a second count of kidnapping. So to hear and see what you had to go through is not something that jurors see every day, and most certainly most people never think about or see. But you've heard and seen the evidence, and later this morning and into the afternoon, you will be doing what you came here to do. And that is to dispense the ultimate form of justice. Not because I'm asking you to do this or suggesting you do this, but based upon the facts and the evidence, the defendant sits there, a guilty person who stabbed his own mother in the neck and then watched her bleed out in front of him. The lady that brought him into this world here on earth, he took out of this world and this earth. But see, at the end of this, he has to watch you come back through those doors. And he has to stand and he has to listen to the verdict. And that verdict is out of my control. It's out of their control. It is 100% in your control. And I have faith and confidence based upon what you heard and saw that you will do the right thing and you will hold him accountable for the fury he unleashed on his mom. Because the cold hard facts and the reality is quite unthinkable when you really think about it. The reality of what that person did to his mom is a second-by-second nightmare for her. She left this world knowing that the person that took her out was the son that she gave everything to. When you're in the quietness and the privacy of the jury room, I want you to take a close look at that knife. And remember, each inch that knife went flying through Kathy Griffith's neck, through each part of her human anatomy that Dr. Graveran described. Because the reality of it, there isn't just a defendant and a victim and this happened and that happened, but the reality of it, for what the defendants accomplished, which is exactly what he wanted to do for so long. The writing was on the wall, ladies and gentlemen. The writing was on the wall. The defendant knew what he wanted to do, and it was just a matter of time. Why? Why did he have such deep-seated hatred for his mom? The lady that was just concerned about him making it to Domino's to work his 4 o'clock shift on Sunday. That's all that she wanted. They can say whatever they want about Kathy Griffith. It's all right. I'm not afraid. You shouldn't be afraid either. Because on Sunday, September 8th, Kathy Griffith did no harm, meant no harm to her son, Collin Griffith. She had one objective only, that cost her her life. And I don't know if it's sad or if it's admirable, but she knew and was willing to die and knew she would die at the hands of her son just to spend some more time with him. We heard from Detective Lacey Zenoniani that Kathy Griffith literally said she knew she would die, but as long as it meant that she could spend some more time with her son, it was worth it to her. And what thanks did Kathy Griffith get from her son? What thanks did she get? She got a foot-long butcher knife rammed into her neck. And you heard the pathway of destruction. Feeling everything through her neck, through those neck muscles, through the esophagus, through the trachea, through the cartilage, and on and on and on. as it ripped through her neck, and the shock and pain going through her body as the defendant was happy. As he followed through with what he said he would do. If nothing else, he's a man of his word. He said he would kill his mom, and he took her out. But you know what? Now he's in a court of law. Now he has to suffer whatever comes his way in the form of a verdict. And that verdict is guilty. That's guilty for what he did to his mom. As she's on the floor trying to get up, but she can't get up. She's got a gaping, open wound in her neck, compliments of her son. Thanks, Collin Griffith. Appreciate that. Kathy, who was literally dusting off his domino shoes, doing us laundry, buying him Starbucks, taking him to the movies, buying him things, getting him a phone, a computer. Now, yes, these are things that you would hope a mom would do, but not all moms do that. Whatever issues Kathy had, she didn't lack for love of her son. She wasn't there to do him harm on September 8th. Her motives were quite simple. Her motives were for Collin Griffith to return to her household by 10 a.m. Sunday. That's all she wanted. She wanted her son, who she was dusting off his domino shoes and making sure that he had a clean uniform, to be home in time to go to work. That's all she wanted. The clock was ticking. Once he turned 18, she knew he was gone. He wanted nothing to do with her. He had told her flat out he wanted to kill her. He had attacked her before. He had already killed somebody in Oklahoma. And she knew what was going to happen to her. But despite that, all that she wanted was every single minute she could have with her son. Well, she got to spend the last seconds of her life with her son as he watched down, as she gushed blood out of her open, gaping wound. The death was not instantaneous. She bled internally. She bled externally. She was fighting to get up. You see her arm finally comes underneath the island. And there comes a certain point, ladies and gentlemen, where that last drop of blood came out of her, where she took her last breath, and she died and left this earth knowing that her son butchered her. And that's the reality of it. You take a look at that knife, and you'll know what it went through, who it went through, who was holding it, what their intention was, and what they wanted to do. Operation Kill Mom accomplished. That's exactly what Collin Griffith did. There's a little PowerPoint here for some things to look at, for you to remember when you deliberate. September 8th, 2024, Kathy Griffith was murdered by Collin Griffith. That's as simple as it gets. But going back the year earlier, the first person the defendant killed before he killed Kathy Griffith, he killed that person when he shot that person 2 times with a handgun. Once in the chest and once in the head. Now you'll remember the importance of that as we continue on. You'll recall when they downloaded the defendant's phone and they saw something on September 8th that Kathy texted Collin. Now, Collin Griffith didn't need a reason or an excuse to be mad at his mom. You've heard through so many witnesses, law enforcement, countless witnesses, that the defendant explicitly verbalized that he would kill his mom. Not only that, but he thought about different ways to accomplish that. And a reoccurring theme was that he would stab her. You don't have to guess what he was thinking or what he wanted to do. You heard from multiple law enforcement officers the defendant's statements about that he would kill his mom. And when they asked how, he gave a plethora of ways, including throwing her out of a car, shooting her. But stabbing her was a reoccurring theme. For whatever reason, the defendant got off on that. And you will recall that the defendant's anger towards his mom, it was already over brimming. But his anger was just intensified when on Sunday, September 8th, the last day of Kathy's life, she wrote the following to Collin. Mind you, her only intention, despite all these threats that she didn't want to have to carry through with, was to get the defendant home. That's it. But she wrote to him, Collin, the recordings of you admitting to killing, and then she wrote the person's name, and planning the murder, there are 4 different instances from my Ring camera, are all going to Bob, Susie, Amanda, and Chris at 3 p.m. today. Plus the recovered audio from Chuck's iCloud, where you told your dad you hated me and I was an evil bitch, are being sent too. Let's stop for a minute. The defendant called and thinks his mom was an evil bitch. That has just so much malice and hatred, once again, to the lady that was trying to do everything she could. I mean, God, we saw Ring videos. She's cleaning all the time. She's doing laundry. She makes sure that his house is stocked with food. She has clean clothes for him. He has his own room. He has his own Xbox, computers, cell phone. She's giving him the credit card to go to Starbucks to buy sandwiches and drinks, taking him to the movies. Anything and everything to make him happy. And you know what kind of thanks she got. Thanks to Collin Griffith, stand-up guy that he is. And then what did she expect from him? Did she expect for him to be remodeling the house or doing all this work? No. She wanted minimal things. She wanted respect, as any mother deserved. She wanted the defendant to pick up a damn finger and do some chores, to weed whack the backyard. Was it 10 acres of property that she wanted him to go outside in the 90-degree weather and push a lawnmower? No. It was a nice, modest backyard that she wanted the defendant to take care of some business, like the man he was supposed to turn into. But if it interfered, God forbid, with him playing video games or him taking his walk, then piss on his mom. That was his attitude. It's 100% his attitude. He didn't want to be bothered. She wanted him to put up a bookshelf. The defendant didn't want to do it. She wanted him to clean up the room because there were a bunch of ants and cockroaches that were crawling around Collin Griffith's candy bags, but it might interfere with him getting some fresh air. So he just blew her off. Day after day, time after time, the defendant wanted to do nothing but what he wanted to do. And you know what? Life would go on if that was the worst of his ways. But he also had that hatred. So every time his mom would ask him to do something reasonable, that hatred would brim. He has told you what he thinks of his mom, that she is an evil bitch. This is what he's saying about his own mom who brought him into this world, his own flesh and blood, and that's what he thinks of her. Kathy continues on. My dad is sending me his recordings of you telling him how you planned my murder back in February. Audio, video, email, text, and phone records are all being sent. So we continue on with the PowerPoint. This is the last day of Kathy Griffith's life. The defendant's life would go on, but Kathy Griffith would cease to exist here on this earth. And there she is on Sunday, unsuspecting the violence that would be coming her way from her son. It should have been just another Sunday afternoon. Should she have not gone over there? Should Collin have gone somewhere else? You know, these questions really don't matter because the reality is what happened. She said there are 2 things that are going to happen. He's either going to come home with me or he can follow in his own car. She didn't say I'm going to go over there and I'm going to smoke him, I'm going to beat his ass, I'm going to stab him, I'm going to shoot him, I'm going to do any of that stuff. She wanted to go over there and bring him back. She didn't even want to have to go drive 2.5 hours over there. It would have been real simple if the defendant just came home. But once again, that's beside the point because the reality is He didn't come home. He didn't want to come home. That's the way life is sometimes. But she wanted to accomplish one thing, to have the defendant come home, not to do him harm, and she did nothing to him. No violence, no threats, nothing. That was it. She even told her mom, one of the last conversations was when she got over there, if he refused to come, then she would call the police. So there's Kathy, wearing the exact clothes that she changed into that she would die in. She was a big fan of coffee. The shirt she was wearing said something about coffee or die. Kind of like the motto, live free or die. So there's Kathy, unsuspecting of what would happen a few short hours later. With her black t-shirt and her jean shorts and her black Under Armour flip-flops that she would be killed in. She picked up her Kate Spade bag, purse, backpack, put it over her shoulder. Interestingly enough, if you call one of the ladies, I don't recall if it was Miss Bell or Miss Jones, but they said when she pulled up and when she got out of the car that she threw her bag over her shoulder and she went up to the house, which is exactly how it appears that she carried her bag. The same bag, ladies and gentlemen, that she was holding when the defendant attacked her and stabbed her in the neck, the same bag that got blood all over it, holding her bag over her shoulder, and her keys and everything else that fell on the ground when the defendant attacked her. Does that sound like somebody, a lady who's attacking the defendant with their bag over their shoulder, holding their car keys and their charger? Of course not, because it didn't happen that way. And then this was it. You all remember when the door closed. In retrospect, it's quite eerie. The door closes. Kathy never returned to that house. That house that she kept immaculately clean. Kathy went off with her bag over her shoulder. A stocked fridge, stocked snacks, clean. Doesn't look like there's a thing out of place. Keeping a clean, safe, loving environment for Collin. Did Kathy have issues? She did. But she's a human being. You heard about her history and what she had to endure. Did that mean she should be stabbed and left to bleed out by her own son? Of course not. That's why he needs to be held responsible. So, this fancy overhead picture. What is the importance of this? Well, now I'm going to talk a little bit about the jury instructions. I'm not going to go into a bunch of jury instructions. You're going to hear those. They're very important. They're long, but I'm going to hit you with two quick things. The first degree murder and the kidnapping. I want you to look at this picture here. This is where Collin Griffith murdered his mom with premeditation and intent. This is where Collin Griffith stabbed his mom and killed her. You see the mulch. You see the entryway. You see the carport. Now you'll recall that Miss Sally Bell, the lady getting ready for church, lived right here. Nancy Jones lived here. Nancy Jones had a more obstructed view just because of the sheer angle of it. This corner here of Susan Detman's house prevented her from actually seeing what was going on. But she did see the defendant reach out, grab Kathy, and pull her in. Now, Sally Bell had a much clearer view. Sally Bell, time is important, okay? Time is important. You guys like a good timeline, and you have a pretty good timeline. Sally Bell goes to church religiously, no pun intended. She gets ready, she leaves roughly a little before 5 o'clock. Every Sunday, her and her husband get ready, they go to church. The defendant wasn't going to church on Sunday, he was getting ready to murder his mom. So Sally Bell, she sees the defendant after Kathy comes over, and is Kathy mad? Is she happy? Of course she's not happy. That doesn't mean she's being violent, and she wasn't violent. She was moving her hands. Sally made it clear. It wasn't threatening or violent or physical. She was animated, moving her hands as she was talking. And she wanted her son to come home. That's it. Nothing more, nothing less. So Sally saw and heard, and it was loud enough because she was inside looking out her front window. She saw the defendant grab his own mom. Remember, this isn't a stranger, which would be bad enough. He grabbed his own mom by the hair He thinks she's an evil bitch. He wants to kill her. He's told people he's going to kill her. He's battered her and attacked her before on November 14th in Port Charlotte. And now he's just doing the same thing again. And his mom paid the price. But you know what? He's going to pay the price when you come back with a guilty verdict. He is going to pay the price because of your verdict. And he grabbed his mom by the hair, and she said, "Stop, stop, you're hurting me, let go." This is his mom begging and pleading for her own son to stop pulling her hair. Who does that? He does that, and he did it. So what happens? Who's doing violence to who? I ask you that. Who is being violent to who? The mom is not being violent in any way, shape, or form to her son. She is doing nothing to him. Nothing to him. But good old Collin Griffith grabs his mom and he yanks her, he pulls her, he drags her. Who cares what verb you want to use? The point of the story is that he pulled her and dragged her into the house. She didn't have a choice because her hair was being pulled and her head and her body was being dragged into the house. Why did the defendant do that? Because he was about to unleash and quench his bloodlust for his mom. He was going to accomplish what he wanted to do for whatever it was, weeks, months, a year. And his bloodlust was going to be quenched at the price and at the cost of his mom and her dignity and her life. So why did he bring her inside? Well, it's quite clear why he brought her inside: to unleash additional violence on her. He wanted to isolate her. He didn't want witnesses to what he was about to do. Okay? That was roughly around 5 o'clock. Now, I want to tell you something. The 911 call was at 6:14, okay? That is an hour and 15 minutes. I'm going to tell you something. They weren't talking or hanging out for an hour and 15 minutes. Quite the contrary. This was a powder keg that was exploding. This was a powder keg that was exploding. What was he doing for that hour and 15 minutes after he killed his mom? Connect the dots, do the math. But as soon as he pulled her inside, it was just the continuation of the beginning of the end. So for kidnapping, I'm going to start with count two. Count two, kidnapping. This is what I have to prove. 3 elements. Collin Griffith forcibly or secretly or by threat confined or abducted or imprisoned Catherine Griffith against her will. That's exactly what he did. He forcibly grabbed her by the hair and pulled her inside against her will. Did she enjoy that? Did she walk into that house voluntarily when Collin dragged her inside? When, as she said in one of the videos, when he already beat her ass on a number of occasions? No. Quite the contrary. He forcibly did those things against her will. So now Kathy knows what's going to happen. Maybe she doesn't know she's about to get killed, but she knows the violence that's about to happen. Because now the defendant has her all alone with no eyes to see, no neighbors to help, and he has her all alone. He's a lot bigger than her. He's a lot stronger than her. He weighs a lot more. He's younger than her. And she was alone. Now, this is no stranger to her. She shouldn't have had to have been afraid of her own son. But now the reality is he's dragged her in by the hair. She's begging for him to let go. But does he care? No. No. And he amps it up even more. He yanks her and pulls her so hard that, as we recall, in the mulch here is one of her AirPods. Boom. They go inside. She would, you know what? She never came out of that house again alive. She came out dead. Dead, with no blood in her body. Thanks to Collin Griffith. This is the last time that she would enter any place. And this is the pathway to further destruction. This is literally the trail to her death at the hands and the knife of Collin Griffith. He yanked her by the hair. She didn't stand a chance. He dragged her, pulled her, get out of the source, use whatever words you want to use, and he brought her, boom, through the living room. Her other AirPod falls out. This is the violence and the force that the defendant's doing. Not only that, she loses her AirPod case. And we know where this is headed. We know the path that this is headed. That house is immaculate. Susan Detman keeps an immaculate house. That is a fact. That is evidence. Susan Detman keeps an immaculate house. Kathy Griffith, her daughter, keeps an immaculate house. There's no signs of a long fight. Kathy Griffith was in no position or no desire to fight. And the defendant had all the power, all the sick, twisted power, all the strength, all the size to his short, defenseless, unarmed mom. Does that sound like a fair fight? Or does that sound cowardly and violent? Well, that's what kept going on. There he is. That is the face of Collin Griffith after he murdered his mom. Those are the eyes that looked at his mom as he shoved that knife so deep in her neck that it literally came out the other side of her neck. That, ladies and gentlemen, is Collin Griffith. Collin Griffith dragged his mom over there. Collin Griffith, in his mind, now we're moving on. Well, I suppose before we move on to the premeditation part, I told you there were 3 elements of kidnapping. We've already hit the first one. Second one, Collin Griffith had no lawful authority to do so. Of course he had no lawful authority to do so. You don't have lawful authority to batter somebody, to grab them by the hair against their will and yank them into a house so you can abuse them and violate them and destroy them more. Element 2 is proven beyond a reasonable doubt. And third, Collin Griffith acted with intent to inflict bodily harm upon or to terrorize Catherine Griffith or to commit or facilitate the commission of any murder. That's a lot of words, but you'll take your time when you have the jury instructions. What did Collin Griffith do? He acted with the intent to harm Kathy Griffith, to physically destroy Kathy Griffith, to terrorize Kathy Griffith, and to kill Kathy Griffith. That third element's proved every which way possible. Because of that, ladies and gentlemen, the defendant is guilty of kidnapping. So when you deliberate and when you talk about the evidence and the law, and when you discuss amongst yourselves, and when you do the analysis, I submit to you that I have proven through the evidence that the defendant is guilty of kidnapping. But only if it could end there. Only if it could end there. Life would have gone on for Kathy Griffith. But it couldn't end there. Because of the defendant's conscious decisions. Because of his actions, it couldn't end there. Life could have gone on, but it didn't for Catherine Griffith because of what the defendant wanted to accomplish and what he didn't stop doing until he had accomplished it. And then to figure out, dang, what do I do now? But you get to see and hear everything that happened next. So we move on to first-degree murder. That, once again, these aren't abstract concepts. This is the reality. That defendant reached into the butcher block and pulled out a knife. It probably made that sound when that metal comes out of the wooden butcher block. Well, Kathy didn't have her AirPods in, so she can hear crystal clear. And that knife comes sliding out of that butcher block. And Kathy would have known at that point that what the defendant had told her, what the defendant had told law enforcement, that he would kill her and stab her, that's how it was going to end for her. So the reality is the defendant pulled the knife. Picture doesn't quite do it justice. I'm not going to stand up here and hold the knife because you're going to look at it in the privacy and solitude of the jury room, and you're going to look at that knife and you're going to see firsthand where that knife has been and who put it there. So Kathy gets stabbed in the neck with such force. You know the pathway. You know everything that happened. You heard from Dr. Garavan, who was very detailed about his expertise, how many countless stabbing cases he's worked. Never has it been an accident or somebody falling on a knife. The force that knife took, the things that it cut through, the open, gaping wound, her bleeding out to the last drop is gone. So, back on September 8th, 2024, after Kathy struggled to get up, struggled to do whatever somebody who's just about to die tries to do, knowing that their son just ensured their death. Mind you, this was at about 5 o'clock, ladies and gentlemen, because that's when Sally Bell saw the defendant yank his mom in by the hair. 5 o'clock. Yet it takes an hour and 14 minutes for the defendant to call 911? Yeah, it did. You're going to hear two clips. One is just the very intro. It establishes the time. It establishes the first words out of the defendant's mouth. Then you're going to hear the defendant's contradictory, absurd attempt at blaming Kathy Griffith for this. For first-degree murder, I have to prove three things. Catherine Griffith is dead. That's an understatement. Number two, the death was caused by the criminal act of Collin Griffith. It was a homicide by Collin Griffith, stabbing his mom in the neck and watching her and letting her and being happy that she bled out and died. And three, there was a premeditated killing of Catherine Griffith. Ladies and gentlemen, when the defendant dragged her inside and dragged her to the back of the house to the kitchen, when he reached for the knife, when he pulled the knife out, think about it. Any step of the way, he could have thought to himself, you know what? This is messed up. I shouldn't be doing this. I can't be doing this. Yeah, I want to kill her, but this is my mom. You know what? Dang, I'm going to stop. I'm not going to do this. He had time to reflect. But his reflection was it Collin 1 or Collin 2? We'll get to that a little later. But his reflection was, yeah, I am going to kill, I am going to stab this evil bitch. And that's not me saying it. That's the defendant's own words. He showed his intentions by his actions and by his words and what he said he was going to do. He was going to kill that evil bitch, his own mom. And so he did. So Kathy Griffith is laid out on the floor, has taken her last breath, has bled out her last drop of blood. Catherine Griffith has been murdered by Collin Griffith. The crime is over. The defendant is guilty of first-degree murder. Now, not to complicate things, but there's another way that I can prove first-degree murder, and I submit to you I've proved it both ways. It's my burden, of course, to prove the crimes beyond a reasonable doubt, but there's two different ways that I can prove first-degree murder. Both end with the same result, which is guilty of first-degree murder. The other way, that I'm not going to spend a lot of time on, but it's called first-degree felony murder. I've already shown you, ladies and gentlemen, why the defendant is guilty of premeditated first-degree murder and why the defendant is guilty of kidnapping. So when you go back and deliberate and when you fill out the verdict form, while it might not be easy and nothing is ever happy about sitting on a murder trial, but you'll know that you did the right thing based upon the evidence and based upon justice. So the defendant's guilty of first-degree murder, premeditated, and kidnapping. Another way that a prosecutor can prove first-degree murder is first-degree felony murder. And I'm going to tell you this first, little insight. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that Collin Griffith had a premeditated design or intent to kill. When you run through the three elements, Catherine Griffith is dead. That's number one. Number two, while engaged in the commission of a kidnapping, Collin Griffith caused the death of Catherine Griffith. And three, Collin Griffith was the person who actually killed Collin Griffith. Her own flesh and blood brutalized her. We'll go to the 911 call, probably an hour or so after he had already murdered his mom.
18/14/11, 2nd September 8, 2024.
911, what's your gasoline emergency?
Hampton, Florida. I don't know the fucking, I don't know the secret.
Now, clip two. What I want you to notice about clip two, ladies and gentlemen, is that the 911 operator asks a very clear, simple question. Listen, what caused the bleeding? And you're going to hear and see, and you probably remember, that the defendant didn't respond for many, many seconds, maybe 6 seconds, he didn't respond. And the 911 operator said more emphatically, listen, what caused the bleeding? And then the defendant gave two diametrically opposed different explanations. Because he wasn't going to tell the truth about what happened, and he was certainly going to try to escape from the charges and blame his mom when he is the person that murdered his own mom. So the first thing he says is, she got into a fight. What do you mean she got into a fight? Like he's trying to distance himself from what actually happened. She got into a fight and she lunged at me with a knife and she fell on it. So that's his first explanation. He's painting a picture that his mom lunged at him with a knife, tripped, and somehow fell on the knife. That's preposterous. Not being disrespectful, but that's preposterous when you think about common sense and you think about physics and when you think about reality. That just didn't happen. The evidence is to the contrary, but that's his first statement, that she lunged at him with this knife and tripped and she somehow falls on the knife. That didn't happen. Then the 911 operator says, where is the knife right now and who did she get in a fight with? And then the defendant says something completely different. Because it's not the truth. The truth doesn't change. The truth is that the defendant stabbed his mom right in the neck, and then it ripped through and came out the other side. That's reality of what happened. And then the defendant changes his story. He thinks he's helping himself by elaborating or trying to prove to himself what happened or prove to others. And then he changes his story. Instead of her lunging at him and falling on the knife, Now he says, she came at me and we got into a fight for a long time. Then she got on top of me and fell on it. Twisted it back, whatever that means.
So listen, what caused the bleeding? Listen, what caused the bleeding?
She got real tight and we went getting into the night and she fell on it.
Where is the knife right now? And who did she get in a fight with?
We came out and we got real tight for a long time. Then we got on top of him and fell on it. Pushed his back.
Collin Griffith murdered his mom, ladies and gentlemen. This is a picture of Kathy Griffith with the person that murdered her son. This is a picture of Kathy Griffith alive and smiling and happy next to the same person that she knew was going to kill her. Yet she was willing to suffer and pay the ultimate price, that was her life, at the hands of her son in order to spend a little more time with him before she left this earth. So that person, Kathy Griffith, live, full of life, smiling and happy, turned into this person. Bleeding out on her mom's kitchen floor with their good old son standing by to watch her bleed out. And there's her Kate Spade backpack purse that was over her shoulder. Once again, you saw it over her shoulder in the video. You also heard from Nancy Jones that when Kathy went up to the house, she had her bag over her shoulder. And that bag got drenched in blood as it literally spurted out of the huge gaping hole in her neck, compliments of her son. When fire rescue shows up and law enforcement shows up, they say they can literally see through her neck. They can see into the organs in her neck. And that is the end result of Collin Griffith's hatred and violence towards his mom. A gaping hole from that knife. And we saw that as she's getting stabbed, she doesn't stand a chance. She comes out of her Under Armour flip-flops. Her keys crash to the ground. Her purse crashes to the ground, falling off of her shoulder. Her charging cords fall to the ground. She struggles to get up. You can see things she's grabbing onto. And she takes her last breath, and she leaves this earth knowing that Collin Griffith, her own son, murdered her. I'll have a chance to talk to you, ladies and gentlemen, after the defenses with a much shorter wrap-up. I appreciate your time. I appreciate your attention. And when you come back through those doors, you should come back with nothing short of pure 100% justice. And that's finding the defendant guilty as charged of both counts for what he did to his mom on September 8th, 2024.
Could you approach off the record briefly this morning? Folks, before you hear from the defense, we're going to just take a short 10-minute stretch break.
All right, please.
All right, everybody, welcome, welcome. Hopefully you guys enjoyed the state's closing argument, but I thought I'd jump on here and talk about this case because I don't think I've come on and talked too much about this during the trial like I normally like to. But why not? This is a great time. State has just given their closing argument. Quite frankly, I was expecting this case to take a little longer. I was surprised that the defense rested after only one witness. But to answer the question there, that was just posed in chat, that's where we're going to start out. Hannah B asked, can someone remind me of what the defense's stance is? Is it self-defense? And I did answer in chat, but I'll elaborate on that answer. And the defense, yes, as you heard on not when this young man was attempting to explain what happened, he originally said she fell on the knife. Then a little, as you heard in the 911 call, all of that was spoken to the 911 operator. So everything you've heard as far as the defense was concerned was emanating from what was basically public record, what was that 911 call, which everyone had heard from day one. Now, what the point of what you've heard, the reason why the defense rested their case, I think, so soon, and they left it at the mom's testimony, and then, of course, you had the detective, I can't remember how to pronounce it, Rabioni or whatever, but those are the two most important witnesses for the defense, because what the defense is going to say, or is hoping to rely upon here, is that the mom had a history of violent behavior. She had a history, not somewhat towards him, but also but towards her previous relationships of domestic violence. Now, what the defense, I think, is going to tell the story, and we'll see here in a few minutes, but I believe the defense is going to tell the story that what you heard in those ring cameras was a simmering, angry, control-oriented mother who wanted to control her son, who wanted to control others in her life. And when she didn't get her way, she got violent, she got angry. And as they're going to focus on the fact that, of course, as this whole thing played out between his mother over the year he was in Florida, that he kept telling people, she's violent, she hits me, she does these things, and I'm going to defend myself. And if she attacks me, I'm going to defend myself. And what they're going to say is that she was the aggressor. She drove 2.5 hours, which, again, I think the prosecutor's weakest argument is the whole idea that he tries to make it sound like, oh, yeah, she drove 2 hours just to go get her son to go to Domino's. I mean, I think anybody that listened to what we listened to, heard the ring camera, knows that she's not coming there from a calm sense. Even one of the neighbors said she saw the mom. It was an aggressive, angry conversation. But what the defense is going to do is they're going to say that she stabbed, or she was arrested in a domestic violence incident that was testified to by Detective Rabioni, or whatever her name was. She told the court that it was testified as evidence that she was arrested for stabbing the father that got killed by Collin. She was arrested as a domestic violence incident for stabbing him. In this case, a knife gets picked up. So what they're going to ask the jury, or at least they're going to say there's reasonable doubt to suggest that when she went in that house and she's all hyped up and she's all angry and she's telling him, you're going to leave and you're coming out, and she's making all these threats. And one of the key things that's going to go to, believe it or not, that may support him is the fact that she was telling the grandma, she's telling him that there's this 10 a.m. deadline that he has to be returned by, or the police are going to get activated. Well, guess what? That detective says there was no police involvement at that point. Nobody was coming to arrest the grandmother. The grandmother had a custody paperwork. She was actually being advised by everyone around her, cool down, let things settle down, and then try to come back and get them. And looks like we're back, so we're going to go back into the courtroom. But let's see what the defense says here.
State's counsel is present. Are we ready for the jury?
Yes, sir.
Thornhill?
Good morning, everyone. Sure seems like the state would like you to focus on the emotion and the drama rather than on the actual facts. You can't ignore the facts in this case. What's your job as jurors? It's to decide whether the state has proved beyond a reasonable doubt that Collin kidnapped and murdered his mother, and that her death was not excusable or justified. That's your job. We start with the presumption of innocence, as the judge will remind you again when he reads the instructions. That means that you have to believe that Collin is innocent, unless and until the state can overcome that presumption with evidence beyond and to the exclusion of a reasonable doubt. Not words that they may say, characterizations of how things might have happened, but actual facts. We can offer interpretations of how you should look at various facts. The facts also include testimony, but it is your job to decide what the facts are and what they mean, and whether the state has used those facts to prove beyond a reasonable doubt that Collin is guilty of anything. So, the state offered a number of witnesses. You guys have been here for over a week now, and they presented a lot of exhibits and evidence. I'm not going to go through all of the witnesses and all of the exhibits. You all took notes, and the exhibits will all be back there in the jury room with you. So you can look at any number of them. You can look at all the text messages that were admitted into evidence, even if they weren't all played on the screen. You can listen to things. You can watch the Ring video. That will be up to you. Those are facts. The witnesses. In a move that you might find surprising, I'm not going to argue to you that the state's witnesses were unreliable or that you shouldn't believe them, with one exception. Most of the witnesses were pretty straightforward in answering the questions. Like I said, it's up to you to decide how to interpret what they said. But the one exception, and it might not even matter in the long run to your inquiry, your decision, because for the most part, what the witnesses told you isn't in dispute. And that one exception is Robert Willantis. I may have seemed harsh with him when I questioned him, and I apologize for that. I wouldn't wish the death of a child on anyone ever. But Mr. Willantis wanted you to believe that he was very close with Kathy and with Collin, and that he was close enough with Collin that Collin confided in him several months before Kathy died. So, how close was Robert Willantis with Collin and Kathy? He was not invited to Kathy's celebration of life. He didn't even know that she hadn't been buried. If you recall him going on and on about how funerals are for those left behind. And that's not to say that it's not to say anything bad about Mr. Willantis, but it's something you can consider in evaluating the credibility of his testimony. He went on one trip with Kathy a few years ago that Susan paid for. He talked to Collin on the phone a total of 3 times, unless you believe that there was this second mysterious phone that Mr. Willantis claimed that he talked to Collin all the time on for either every week or every other week. There's no evidence of that. Susan told you about a phone that she got for Collin when Kathy had kicked him out one of the several times that she bought for him to use because he'd been kicked out without his phone. It was active for a couple of weeks. It's another thing you can consider in deciding whether you think Robert Wolantis was reliable. You also have to consider whether Robert Wolantis was trying to make himself seem more intimately connected with his daughter's life and his grandson's life, and now with Kathy's death. Remember, he was the one who called Polk County Sheriff's Office. He was not the go-to family member that the detectives wanted to speak to get information. They didn't seek him out. He reached out to them. And he reached out to them only weeks after Kathy died. Not right away, not, oh my goodness, my daughter died. I have this important information that may help in the investigation. No, it wasn't until after he watched Grady Judd's press conference that was extremely detailed in describing the wound that Kathy suffered and how she died that Mr. Wolantis called the sheriff's office. You can consider that in determining whether you think his testimony is reliable. You can also consider the language he used in describing what Collin said to him, allegedly, about wanting to slit his mother's throat and watch the blood and life seep from her. You've heard Collin's words several times on the 911 call, on the Ring videos. Does that sound like something Collin would say, or a way he would describe anything that he says? Or does that sound like Mr. Wolantis putting words in Collin's mouth? All that to say, even if you believe Mr. Wolantis, which I urge you not to believe what he said, he claims Collin told him, but even if you do, that does not prove beyond a reasonable doubt that Collin murdered his mother. And you have to remember that too. That's what the state has to prove to you. So dealing with that one witness, let's move on to the charges against Collin. The kidnapping. The state has to prove to you beyond a reasonable doubt that Collin, by force, threat, or secrecy, confined, abducted, or imprisoned, or isolated Kathy against her will. And at the time he supposedly did any of those things, at that time he had the intent to commit great bodily harm or terrorize her. Okay? So what did the state present to try to convince you that there was a kidnapping? They presented the witnesses, the neighbors, Sally Bell and Nancy K. Jones. Both of them are neighbors of Susan's. You've seen the photos of where they lived. And you heard them say that Kathy was the one being aggressive right when she arrived. She whipped the car out of the driveway to pull it up against the curb or the grass. She slammed her car door, she slung her backpack over her back, and she marched up to the door and went inside. Went inside that house of her own accord. When she comes back out of the house, she's throwing things into Collin's car, and you can see in the photo of the interior of his car, there's clothes thrown in the back, and there's his computer and his phone on the front seat. And she's yelling and gesturing and stomping around, and then she goes back up to where Collin is standing in the doorway. Because remember, neither of those witnesses told you he was ever anywhere other than in the doorway. Not in the mulch where an AirPod was found, but in the doorway around the corner. So Kathy comes up to him. She's making a scene, obviously a scene that's loud enough, noticeable enough that the neighbors are looking to see what's going on. She's already drawn their notice. And as she's on the carport floor and Colin's standing in the doorway and she's still gesturing, he puts his hand, and the witnesses differ, on her neck area, on her shoulder, by her ponytail, and they said pulled her inside. Not dragged, not grabbed her by the ponytail, more like, and this is something you can decide, more like an ushering, like, oh crap, you're causing a scene, like you know Kathy can, seeing it in the state's own evidence. Let's bring this inside so that we don't get the wrath of the neighbors up or cause attention to be drawn even more to our argument. That's a more reasonable interpretation of those facts. It's reasonable to interpret that Collin was embarrassed by his mom and didn't want to air their dirty laundry in the carport. Now, she did say, "Let go, you're hurting me." Okay? That's a fact. That she said that is not in dispute. But you can't just accept a statement by anyone, but let alone by Kathy, at face value. Okay? So, she claims, "You're hurting me, let go." Does she pull away from him? Nope. Witnesses never said anything about that. Did she try and stay at the bottom of the steps where she was gesturing at him? No, the witnesses didn't say that. They said that her feet actually moved up the steps. That indicates a willingness to go inside. That's a reasonable interpretation of what those witnesses told you. Did she say, "I don't want to go back inside"? No. Did she grab onto Collin in some way to get him to let go of her? No. Did it even look like she was actually being hurt? Don't you think, isn't it reasonable that if Sally Bell or Nancy K. Jones thought that Kathy was actually being harmed in any way whatsoever, that they wouldn't have either called 911? Kay Jones would have called Susan because, remember, she was house sitting. She was aware that Collin was allowed to be there, that he had arrived the day before, his car hadn't moved. So she's sort of keeping an eye on the house. If either of them thought that Kathy was actually being harmed or being forced to do something against her will, don't you think, as the good neighbors that they were, they would have alerted someone? They didn't, because Kathy's saying she was being hurt and let me go, and they don't know her. But I think you can interpret that statement from Kathy, knowing what you know about Kathy, as being just one of the many things that she claimed happened that didn't actually happen. For instance, when she said on one of her multiple phone calls to Susan or in a text to Collin, there are a lot, so I'm sorry if I don't remember exactly where it came from. She said, "I'm scared, Collin, you battered me or you hit me or you beat me before you left on Saturday." Remember the ring videos? In every room in the house except the bathroom. And for the most part, she and Collin are on ring video. The state has given you some ring video. The defense has given you some additional ring video to sort of fill it out a little bit better. On none of that ring video is Collin ever touching her. So isn't it reasonable that even though she claimed Collin hit her, beat her, struck her before he left the house on September 7th, and there's no proof of that, that her saying, "hurt me, let go," was just her making something else up? There's another reasonable interpretation of Kathy saying, "You're hurting me, let go." Remember, she was furious with Susan, with her mom, like furious. You heard her yell several times on the Ring video at Susan. She was pissed off that Susan had let Collin come to her house, which, as you may recall, I asked several witnesses about this. And the reason I asked them about this is because I wanted it to be clear that it was permissible for Collin to be at Susan's house. It was permissible to his probation officer, who he emailed. It was permissible to the courts. You saw the pink paper that Kathy tried to make a big deal out of that said Collin may go to visit his grandmother out of county, just notify the probation officer. It was permissible under the 751 plan, the concurrent custody. There was nothing anywhere or in anyone's mind, except perhaps Kathy's, that said that Collin was not allowed to be at Susan's. Nevertheless, Kathy's pissed at her mom because Collin is at her house and hasn't come home as quickly as she demanded. Remember, she'd also made some threats to Susan in her text, saying, "Your HOA hates you, and Freddie, Susan's dog, doesn't have a dog tag, and that's a violation." A violation of what? I don't know. But Kathy's mad enough at Susan at this point that who knows, maybe she was trying to get Susan in trouble with her homeowners association by causing a bigger scene than it actually was. I'm not saying that's for sure what happened. I'm giving you reasonable interpretations of Kathy's behavior. But the bottom line is that there's no evidence that Kathy did anything against her will that day. And certainly no evidence beyond a reasonable doubt that she went back into the house that she'd already been in on her own, despite Collin touching her neck, her hair, her ponytail. She was not being dragged. She was not being forced. Plus, once she's in the house, the state has one theory of what may have happened. I'm going to propose some other, I would argue, more reasonable ones. When she's inside the house, she has access to her phone, right? She has access to car keys. The doors are unlocked. You heard Susan say that the doors are kept unlocked, and then you heard Collin say on the 911 call when law enforcement first arrived and they're knocking on the door saying sheriff's office, he says, "Come in, the door's unlocked." There's no evidence that Kathy was kept in that house against her will. None. In fact, to the contrary, Collin would have been probably really happy if Kathy had left. No one wanted her to have come there. And knowing what you know about Kathy, don't you think it's reasonable that if she had been forced to go back inside against her will, that she wouldn't have fought tooth and nail to avoid doing what she didn't want to do? Remember, this is somebody that the state's own witness, Detective Zanoniani, said it's either her way or the highway. So, knowing what you know about Kathy, if she was being forced to do something against her will, it's reasonable she would have fought it, right? The state himself said it doesn't look like there was a long, drawn-out fight throughout the house. If Kathy didn't want to be back in that house, how did her flip-flops make it all the way to the kitchen? If Kathy didn't want to be back in that house, she would have been flailing, like she had been doing just talking to Collin before. And if she had been forced to go back into that house and then forced to go to the kitchen and forced not to leave, the house wouldn't have been in as pristine a condition as you saw. The plant would have been knocked over. Something would have been amiss. Didn't have any evidence from the medical examiner either to say she had any scalp wounds or anything indicating that she had been pulled by the hair. Not to mention the fact that, is it reasonable to you that Collin, despite what the prosecutor says, even though there's no evidence of how tall he is, how much he weighs, you've seen him in court, you've seen a picture of him shirtless. If you believe that Collin could have made his mother do anything physically, I don't know what else to tell you. I'm not going to be able to convince you of anything. And if you think that Collin was dragging her by the hair, as the state seems to want you to believe, throughout that house, how come her flip-flops didn't come off right at the front door? Collin didn't make Kathy do anything. Oh, but the AirPods, the one in the mulch, that proves that Collin made Kathy do something against her will. BS. No witness ever saw Collin in the mulch. They never saw him anywhere other than the doorway. But they saw Kathy march her way up from her car to the doorway. Isn't it reasonable that as she's pissed off at Collin, comes in hot and angry, that it fell out while she was just being herself? Same with the ones in the house. Once again, if Collin was ever forcing her to do anything physically against her will, and that AirPod came out because of something he did, you think she would have just been like, okay, I'm going to let you keep dragging me, instead of flailing about and, like I said, knocking something amiss in the house? No, that's not reasonable, because none of that ever happened. There was no kidnapping, period. The felony murder count, which is also first-degree murder. If you were to find Collin guilty of that, that would mean you have to find beyond a reasonable doubt that he kidnapped Kathy and that during that kidnapping, he caused her death. So I've already told you all the reasons why I think the state has utterly failed to prove a kidnapping. But even if you did find that, because I don't want to presume that you're going to find anything. I'm here to make suggestions, not to tell you how to do your job, like the prosecutor was trying to do. That hour and 15 minutes between when the neighbor saw Collin usher his mother inside as she's making a scene and when he called 911 distraught, you would have to believe that Collin forced Kathy to stay in that house that entire hour and 15 minutes and was inflicting some bodily harm or terrorizing her that whole time. That's not reasonable. There was no kidnapping, and this was no felony murder. This was self-defense. So, the state wants you to believe that this was a premeditated murder. In order to do that, once again, they have to prove beyond a reasonable doubt that Collin intended to kill her, and beyond a reasonable doubt that he was not acting in self-defense. That's what you would have to find. You heard a lot of outrage from the prosecutor in his closing statement. And this is an awful situation. But there was no outrage about how Kathy had behaved, how Kathy had treated her son, how she had treated other people. And I'm not saying you have to have outrage at that. You've heard a lot of unfavorable things about Kathy. And I am not going to go through every single one because you took notes, you heard and saw, you heard from the state's own witnesses, those things. Susan confirmed them. But remember, the incidents that you heard about Kathy being violent in the past or making things up in the past were all corroborated, either by police reports, DCF reports that Detective Zanoniani had reviewed, or by witnesses, by Susan. I was not presenting those to you to just bash Kathy, to make her look like a horrible person. To the contrary, I was doing my job because the law says, and the judge will tell you, that you have to consider prior acts of violence, prior acts of aggression, a reputation for dangerous and violent behavior, in deciding whether Collin was reasonable in defending himself against his mom on September 8th. I'm not going to read the instruction in detail because, like I said, the judge will do that for you. But the law requires you to consider what Collin knew about his mom to decide whether you think he acted reasonably in defending himself. You have to decide the reasonableness of Collin's actions in light of all of those things. In light of the fact that she had pulled a gun on him before, in light of the fact that she had threatened to kill other people before, in light of the fact that she had attacked other people before with weapons. Some of these things in front of Collin. So it's not even just hearing about it, it's witnessing it. He knew all those things about her. He knew what she was capable of when she was angry. He knew all of this, and it was in his mind when she came to him on September 8th. Collin also knew that Kathy would sometimes make things up to hurt other people, such as he knew that she claimed someone strangled her. She even claimed that she had video of it, but when the police reviewed it, it showed you she was strangling herself. He knew that she had called DCF on her own brother, got them involved in an investigation that was baseless. He knew that his mom claimed to do everybody else's schoolwork, including her own mother's dissertation for her PhD. He knew this about his mother. Now, luckily, those threats and made-up stories that Kathy had told in the past didn't ever result in any serious consequences for those people. But Kathy had never suffered the consequences of making those stories up either. And what happens when you don't suffer consequences? You continue the behavior. And sometimes she was actually even believed when she made things up. One glaring example. The day that she pulled the gun on Collin, threatened to shoot him or herself, and then handed him the gun and said, "Just shoot me," Collin immediately tells his teacher or professor, who talks to the school resource officer, who gets the deputies involved. The deputies go to Kathy at her house, and Kathy says, "No, I never pulled a gun." "What? He's just being a brat. He was failing classes, so I disciplined him by taking away his phone and his AirPods." And they believed her. Okay? Now, at the time, maybe that wasn't so astonishing. But remember what Susan told you. Susan told you that Kathy admitted to her that she had actually pulled a gun on Collin. So Kathy lied to the police. She also lied about him failing his classes. That was never true. And convinced them that Collin was just being a brat. Despite the fact that Collin had given a detailed account of what his mother did to him with her gun, they didn't believe him. They believed that he was just being a brat. Don't get me wrong, Collin could be a brat. I am not trying to make him look like an angel and Kathy look like the devil. You heard him on the Ring video and how he talked to his mom. Disrespectful, absolutely. But that doesn't make him a murderer. Also, look at his role model. That sounds awful, but we all talked about in jury selection that kids kind of do what they know. Their parents are their role models. Their parents teach them by not only talking to them, but by their own behavior. They cussed back and forth at each other. Is it an ideal parental-child relationship? No, but that's how they existed. You heard Kathy cussing at a number of people, including her mom, and cussing and claiming Collin had put a lid on her cup too tight and that it caused her to cut her hand. Did you see a cut on that video? Did you see her trying to stop any bleeding? No. Another example of her making things up. So even though Collin could be a brat and disrespectful to his mom, but what 17-year-old isn't at times, you cannot ignore the fact that Kathy told her mom, yeah, I lied to the police. I actually did pull a gun. You cannot ignore that fact. And it was in response to his mother pulling a gun on him that Collin started making these statements that the state has conveniently termed threats, but without wanting you to consider all of the words in those statements. And that was the same incident where Kathy lied to the police about not pulling a gun on Collin. Remember, he ends up Baker acted because he begins the litany of times that he said, I don't feel safe with my mom. I'm afraid what she'll do to me. I'm afraid if she pulls a gun on me again, I'll have to defend myself. If she does those things that we now know she did, I will defend myself. You even saw him on body-worn camera footage telling the officers that. If she does this to me again, if she punches me, if she attacks me, I will defend myself. I'm afraid I don't feel safe at home. But no one would listen. Over and over and over, he tells people in authority this. They believe Kathy, they don't believe him. I want to propose a possible reason why they didn't listen to him. Once they found out that he had been arrested for a shooting death in Oklahoma, despite the fact that he was never charged with that, everybody decided, we can't believe him. We have to believe her. Look at his past. And that is an awful shame, because there are facts and evidence to show you how Kathy behaved. You have her own words to her mother that she pulled a gun on her own son. People in authority ignored Kathy's well-documented history of violence towards others. They ignored her well-documented history of aggression and volatility and impulsivity. They ignored the fact that she owned a gun. They ignored the things she had done to her ex-husband. They ignored that she had stabbed him and burned him and pinned him to the house. This is all in police reports and DCF reports. They just ignored it. And these are just the documented episodes that we know about of Kathy being violent towards others. You saw how she acted on her own Ring video, right? And this is her knowing she's being recorded. So if that's how she behaves when she knows she's being recorded, think about what she might do when she's not being recorded. We also know she beat Collin with a belt in front of her own mother. And when Susan tried to intervene, she tried to claim that law enforcement had sanctioned that behavior. She claimed that Corporal Rentis told her it was okay. Well, you heard from Detective Zanoniani that law enforcement would never sanction such a thing. The day before Kathy died, you've seen the Ring video. You saw that she and Collin had an argument about putting up the bookshelf. You saw that he was disrespectful to her, but you also saw that her reaction to that was to kick him out, which she lied about later too. She claims on the phone with her mom on the Ring video, I never kicked him out, I never kicked him out, I never kicked him out. Watch the Ring video again. Listen to her words. Get out and don't come back even if you're bawling your eyes out. Beyond that, give me your house keys. She took his keys to get back into the house that he lived in. You can't see it in the State's Ring video that they played, but I admitted a defense exhibit that we only played a short clip from, but it's longer. You can watch it if you don't trust me or don't believe me. But in that clip that you didn't see but is in evidence, it shows the view from the living room, and it shows her actually taking the keys from Collin and putting them on the hook inside the door, and then her closing the door and locking it behind him. And you may also remember that the key ring that was on the kitchen at Susan's house was just a car key with no house keys on it. Yeah, those were to Collin's car. No house keys. So, she kicks him out over him not helping with the bookshelf. Should he have helped her? Probably. But was it so unreasonable to think that if you put up a bookshelf that's not anchored to studs that it might be a problem? So all of this is going to Collin's state of mind the day before Kathy comes to him at Susan's house. It's something you must consider when you're deciding whether the state has proved with facts and evidence beyond a reasonable doubt that Collin wasn't reasonably defending himself against his mother on September 8th. And would a reasonable person defend themselves like Collin did? Sort of on a separate note, the state has argued that the text that Kathy sent to Collin, threatening all sorts of things, because you know she threatened all sorts of things that were not true, right? Won't go through all of them. But this text where she says she's going to send all these ring videos of him supposedly confessing to planning a murder in Oklahoma, that provides a motive for Collin to want to kill his mom. Okay, first of all, you have to believe that the threat was true. Given what you know about Kathy, given the fact that no one's seen any ring videos of any such nature, and given the fact that Collin has never been charged with anything in Oklahoma, and given the fact that her deadline of 3 p.m. when she was going to supposedly send these to all these people had long passed before she got to Collin, isn't it reasonable to think this is just another thing that she made up? Because if those things existed, they'd be out there. They would have been in front of you. And don't you think Collin knew that that was an empty threat? Knew that no such recordings existed? So this big motive that the state wants you to believe in, also BS. Just another one of her delusional lies. Something else she made up, like she made up things all the time, and that the state's own evidence proves to you. Then you have to think, even if you believe that the threat was true or real, beyond a reasonable doubt, you have to believe that Collin somehow made her come to him so that he could kill her. And that's just absurd. Kathy made the choice to go to where he was. And let's face it, Collin had been trying to escape his mother for quite some time. For at least a year that we know of, since September of 2023, when he got put in the Baker Act facility for something his mom did and lied about, when he said, "I don't feel safe." And that's what he was trying to do on September 8th when she kicked him out. On September 7th when she kicked him out. He was trying to escape her. Think about this. All the times that you've heard about Collin saying, "I don't feel safe. If my mom attacks me, I'll defend myself. If she comes at me, if she pulls a gun on me, if she punches me, I'll defend myself." Remember, Collin told people that he would rather be in the Baker Act facility than at home with his mother. He told people in authority he would rather be in jail than at home with his mother. He told people in authority he would rather be in foster care than at home with his mother. And the state wants you to believe that Collin's just a brat who didn't like the discipline he got, so he murdered his mom. That's also absurd. Because, as the state has pointed out many times, Collin had what they think is a great life with mom, right? So he gets to go on trips, absolutely got to go on trips. He lives in a clean, nice, organized home with plenty of food, yes. He has a phone, he has an Xbox, he has a computer, he gets to go to college. Don't you think Collin, as smart as he was to be able to graduate early, would know that if he actually were to be placed in the Baker Act facility instead of going home with his mom where he didn't feel safe, or remain in jail instead of going home with his mom with whom he didn't feel safe, or went into foster care instead of going home with his mom with whom he didn't feel safe, he would get none of those wonderful things. None of them. He would not have a phone. He would not have an Xbox. He would not go on trips all over the country or the world. And yet he still said, "Please, re-Baker Act me. Please, don't send me home from jail with my mom. Please, I'd rather go to foster care." These are the things you know, and that the state has proved. Collin was trying to escape his mom because he was scared. He was scared of what she would do to him, and if she attacked him, what he would do in response. So, knowing all that, let's talk about September 8th. Kathy went to where Collin was. Isn't it reasonable to believe, because let's be clear, the state has offered no proof, zero proof of what actually happened in Susan's house on September 8th? None. Zero proof does not equal proof beyond a reasonable doubt. But isn't it reasonable to believe that Kathy, in her anger, her desperation to make Collin come home, that she picked up a knife and threatened him with it, which is in total conformance with how she's acted in the past? Absolutely, it's reasonable. The state wants you to think, despite any proof, that Collin dragged his mother to the kitchen, somehow kept her there against her will, either by beating her or holding her by the ponytail, and then somehow managed to get a knife out of the butcher block while still holding on to Kathy, such that she couldn't get away, to start this fight over the knife. That's absurd, and it certainly hasn't been proved beyond a reasonable doubt. Isn't it more reasonable, given everything you know, that Kathy picked up the knife, threatened Collin with it, and he defended himself, as he's been saying he would do for a year? Isn't it also reasonable that Kathy knew what the outcome was going to be when she picked up a knife and threatened Collin with it? You've heard of suicide by cop? Isn't it reasonable to think that Kathy committed suicide by son? She had never been able to successfully commit suicide before, despite her many attempts. Isn't it reasonable that she pulled a knife on Collin, knowing that if she attacked him, that he would defend himself, and that the end result might be that she died? I'm not saying that that's what was in her mind, because we don't know what was in her mind. I'm saying that it's a reasonable possibility given everything you know about her. It's also a reasonable possibility, a reasonable interpretation, that she attacked Collin with the knife. He has wounds. Dr. Garavan talked to you a little bit about mutual combat and how a struggle over a weapon can result in both people with wounds, which is what you see here. Exactly what you see here. You also, most of you in jury selection mentioned that self-defense is a right that each of us has. And those of you who own guns said that they keep them nearby, often for protection. And I said, protection from what? And you said, if someone comes into my house and attacks me, I can protect myself and my family. So isn't it reasonable that that's what Collin did here? When Kathy came into the house where he was living, for all intents and purposes at that point, and that she attacked him with a knife, that he defended himself, as was his right? The state has proved at no level, let alone beyond a reasonable doubt, that Collin picked up the knife and attacked Kathy with it. That means you have to try and figure out, if there's no evidence of exactly what happened, you have to think about what was reasonable. And it makes way more sense, given what you know, that Kathy attacked Collin and he defended himself. They've tried to get you to believe that Collin was rage-filled and hate-filled, and all of these malicious thoughts were geared towards his mom. If you believe that beyond a reasonable doubt, don't you think there'd be more than just one wound on Kathy? Sorry, she had 2 wounds. She had the neck wound and she had the hand wound. Those could have happened at the same time. You don't know whose hands were on what part of the knife during this struggle. If Collin was so rage-filled and had such hatred for his mom, don't you expect that there would be 5, 10, 20 stab wounds? That's something you can consider too. So the state played parts of the 911 call again for you, and they want you to believe that that proves beyond a reasonable doubt that Collin murdered his mother and wasn't just defending himself. You can believe or disbelieve what Collin said. If you don't believe what Collin said, that still doesn't mean that the state has proved beyond a reasonable doubt that he murdered his mother. Remember that. Also consider that Collin said there was a long fight and she fell on the knife. Knowing his history, don't you think of not being believed by people in authority repeatedly, that yeah, he may have not told the entire truth because he was scared. That doesn't make him a murderer. Especially because when he went to the people who were supposed to protect him, law enforcement, doctors, DCF, and said, my mom attacked me with a gun, my mom pulled a gun on me, I don't feel safe, I'm afraid, I'll defend myself. Don't you think and then believing her when she says, absolutely never happened, he's just being a brat. Don't you think he might be a little scared when he's talking to a 911 operator? Not to mention the possible shock because of what he had been through in a struggle over a knife with his own mom. And let's not forget the one wound to Kathy's neck. State wants you to believe that it was some vicious, forceful, rage-filled wound. But remember what Dr. Garavan said? He said that it actually doesn't take much force to go through the soft tissue in the neck. The biggest point of resistance is the skin itself. And that resistance is even less if the knife has a pointy triangular tip, which is what we have here. So, knowing that it wouldn't take much force to inflict that wound, knowing that Kathy has been violent in the past, knowing that she has threatened people in the past, knowing that she has attacked other people, isn't it reasonable that she pulled the knife on Collin, he defended himself, and there was a long fight over the knife. The messiness of that confined space between the island and the cabinet and the stove supports that there was a struggle over a knife. And don't you think it's reasonable that during a struggle over a knife in that confined area, and who knows what positions anybody was in, state sure can't prove any, that gravity may have played a part in that little bit of force that was necessary to cause that wound? As I said, these are interpretations based on what you do know. But don't forget, I don't have to prove exactly what happened. It's the state's responsibility to prove to you beyond a reasonable doubt that Collin did not act in self-defense. So let's talk about what the state may have proved beyond a reasonable doubt. One, by way of stipulation from us, that there was no foreign DNA under Kathy's fingernails. Okay, that's something you have to accept as true. What weight to give it is up to you, but so what does that mean? That means she never scratched Collin with her fingernails. That's it. Or at least not on the fingernails that they took the swabs from. So why is that important, or why should you consider that? Well, you would expect she would have scratched him with her fingernails if she was actually being dragged into the house or across the living room into the kitchen and being held against her will. No DNA, no scratches. That means no struggle with just her fingernails. So that piece of evidence does not establish anything beyond a reasonable doubt as far as whether Collin is guilty. You know why else she wouldn't have to scratch him at all? Is if she had control of the knife. Because she doesn't need to scratch him and defend herself with her fingernails because she had the knife first. That actually supports that she pulled the knife on Collin first. They've also proved beyond a reasonable doubt that Kathy had bruises all over her body. Okay? Keep in mind that the lighting in the morgue, when pictures are being taken for evidentiary purposes, are a lot different than pictures you take with your cell phone. There has been zero proof of how Kathy got those bruises. Dr. Garavan can't date them. He said they could have come from innocuous activities like doing chores around the house, like you saw Kathy doing on the night of the 7th. Certainly no evidence to show that Collin somehow inflicted those. So even though they've proved that there are bruises, they have not proved how those bruises occurred. So essentially meaningless. Or another possibility, reasonable interpretation, is that she got bruises while they were struggling over the knife. The state has also proved beyond a reasonable doubt that Collin had blood on him. So what? He had wounds. He performed life-saving CPR on his mother at the instruction of the 911 operator. He held towels in his own shirt to her to try and stop the bleeding. You saw the bloody towels. It also supports that there was a struggle over the knife. It does not support that Collin murdered his mother. The blood on his eyeglasses frame, I hope that was clear when I was asking the crime scene tech that if somebody's holding towels and doing CPR and in this confined space, that they might adjust their glasses and get blood on it that way. But what about the blood on the backpack? Does that prove Collin's a murderer? Absolutely not. Remember I asked the question about the Collin's phone being in the car and that Kathy's phone could have been in her backpack and that was Kathy's phone that was used to call 911? So blood being on the backpack doesn't prove Collin's a murderer either. It may prove that Collin, after he tried to stem the bleeding before he called 911, had to go look for the phone to call 911. Or that in their struggle over the knife, before he called 911 in that confined space, that's how the blood got on him. The other thing that the state has proved beyond a reasonable doubt is that Collin has said over and over and over and over and over and over, I don't feel safe with my mom. I'm afraid she'll attack me. I'm afraid she'll hurt me, and I'll have to defend myself. They've tried to skew the statements to make it sound like he just walks around going, I'm going to kill my mother, not if she does something to me first. So I want you to think about this. If Collin really wanted to kill his mother, and that he wasn't acting in self-defense, why on earth would he have telegraphed this to every person in authority at any chance he got? He told people in authority that if she attacked him, he would defend himself because he was scared. He was scared of what she would do, much like Susan said she was scared of what Kathy would do. You can also consider that if he, for months, if not longer, wanted to just kill his mom, and this is a little sick, but there were a number of ways he could have done it that would not have implicated himself, especially after he's told people in authority, if she attacks me, I'm going to defend myself and I might kill her. One of the many cruises they went on could have pushed her off the cruise ship. Could have slipped some of her medication, legal or otherwise, into one of her many drinks. Could have shot her. If he was as forcefully strong over Kathy as the state wants you to believe he was, he could have forced her into the bathroom in their own home where there were no ring cameras and slit her wrists in the bathtub. And in any of those scenarios, he wouldn't have had to rely on her coming to him, her driving hours to get to him. He didn't want to kill her. You heard him on the body-worn camera footage. I don't want to kill her, but if she attacks me, I will defend myself. The state has proved nothing of significance beyond a reasonable doubt to you, except that Collin and his mom had a very disturbed relationship. And also perhaps that they never should have been living together. You heard about other family members who were periodically estranged from Kathy. These were all adults with their own lives. Collin, who also clearly wanted to separate himself from his mother, was still a kid without the agency or the autonomy to really sever any connection with her. Right? He's telling people, I don't feel safe, I don't want to go back with my mom, and yet they kept making him do that. It's kind of like someone saying, say, a zoo worker or a circus worker that's responsible for taking care of a lion in a cage. Don't make me go back in that cage with that lion. It's bared its fangs at me. It's reared up at me. But luckily, every time I was able to get out before it attacked me and caused me harm. And the zookeepers and the circus people kept saying, he'll be fine, go back in the cage, and closing the door behind him. Doesn't mean that the lion is in attack mode all the time. The lion could be majestic and charming to audiences and cute even sometimes. Could seem calm, like you'd want to pet it. But it was, after all, a violent being. And just because the poor zoo or circus worker was forced to go back into that cage time and time again, when the lion finally managed to attack him and he couldn't get out, you can't blame the person who was forced into that cage over and over and over for defending himself. Each one of the authority figures that Collin begged to take him away from his mother ignored him, failed to protect him. They had the power to make the if part of Collin's statements that he might harm his mom not come true. And they didn't. So, been through a lot. Gonna give you one final thought. Remember again that Collin is presumed innocent. Okay? Unless and until the state can prove beyond a reasonable doubt with evidence and facts that he kidnapped and murdered his mother. So that's like saying you have to start with seeing the vase in black. That's the presumption of innocence. In order for the state to overcome that presumption of innocence, they have to provide you with facts such that you can only see the faces, such that you don't see the vase anymore. If you can see both the faces and the vase, that's reasonable doubt. The state has in no way come close to proving to you beyond a reasonable doubt that only the faces exist. They have failed to prove beyond a reasonable doubt that Collin did anything other than defend himself against his mother, and that what he was afraid would happen actually happened. Your verdict has to be not guilty. Thank you.
Thank you, Ms. Gardner. Members of the jury, we're going to take one more 10-minute recess. I think you need to finish making your lunch selections, because we'll hear from the state in rebuttal, and then I'll go directly into the instructions. So we'll take 10 minutes.
All rise, please. May be seated.
It will be in a 10-minute recess.
Then Cedar.
All right, we're back on the record. Mr. Griffith is present with both lawyers. Mr. Levine is here for the state. Are we ready for the jury?
Yes, sir.
Yes, sir.
All right. Please be seated. Mr. Levine, rebuttal.
Thank you, Judge. Ladies and gentlemen, you're about 6 minutes away from hearing the jury instructions. It's going to be a lot shorter than the first time around. And we're going to finish up with the rest of the PowerPoint. Those two photos there, as you heard Dr. Garavan say, are consistent with defensive wounds. Open, gaping, fresh defensive wounds. Kathy doing what she could with her bare hand to try to prevent that knife from going through her neck. Remember, the defendant, his hands were pristine. No cuts, no bruises, no stab wounds, nothing. Because Kathy never had that knife. So, how did this happy, smiling young lady turn into those last photographs you saw?
A couple of quick yes or no questions I almost forgot before we go. And do you think he's capable of killing you?
Yes.
She was quite aware that he was capable of killing her.
Okay. All right, well, thank you for your time.
Now, how did the defendant act when his mom did something as simple as take away his Xbox and his phone to try to instill some discipline discipline action.
You stood up and said, okay, let's do it, let's do it. Yes, you did. I was there.
I was saying, no, I'm not a psychopath. I'm not this murderer.
Why does she think he's a psychopath and a murderer? Sometimes when you protest too much, you're scared of the reality.
I'll say it to you like this, if you want to know. Collin 1 is, I guess, he's who just wants to survive, help people, and do good things in the world. And Collin 2 is the one that protects Collin 1 in situations where he can't escape from. And Collin 2 is the one that killed someone. Because what's it going to come down to next time?
I don't think you're a pussy. I think that you are capable of killing your mother, but I don't think that you will.
No, why would I?
Collin, I will let you get to that. Do you think Collin will let you get to that? I can't hear you, sir. But why Collin? You're a strong individual. Why would you submit in a roundabout way to Collin? When we talk about...
It's the strongest version of me.
Ladies and gentlemen, the defendant knows the strongest version of him is the one that kills and murders.
So how is the situation with you and Mom right now? Things calm down?
No,
you guys everybody's getting along? Where are we at?
No, sir, it's not good. She thinks that I do shit out of her. I don't. She thinks that I'm like psychotic, like literally psychopath, sociopath, something like that. I don't know exactly where she's at. She thinks I'm gonna kill her.
She's 100% on the money.
Okay, what about you doing something to her? Are you able to control yourself?
I'm in a constant state of fight or flight, and I don't know. If I think she's gonna do something, even if she's not, I might act.
Oh, he acted all right. This is what the defendant said to his own grandpa, Robert Willantis, whose daughter was brutalized by the defendant. My grandson was very aggravated at his grandmother and his mother. He said, I am so tired of these two bitches. I'm disgusted. He said, my mom, I keep thinking over and over, I want to slit her throat. I want her to bleed out. I want to smell the blood. I want to feel the blood. I want to feel the life in the blood leaving her body. And that's exactly what he did. And that's just not Robert Willantis saying that. When you look back at the text message that Kathy sent to the defendant before she came over, she said to her son, my dad is sending me his recordings of you telling him how you planned my murder back in February. So that just corroborates what you should already know, that Robert told his daughter what was coming her way. And what was coming her way was exactly what the defendant said he wanted to do with her. And that, ladies and gentlemen, is exactly what he wanted to do as he left his mom with that gaping hole, just as he said he would. So the talk is done. Now it's time for action. When you go back in that jury room and deliberate, come back, dispense justice in the utmost way. Thank you.
All right, members of the jury, Thank you for your attention during the trial. Please pay attention to the instructions you're about to receive. Now, if you've been taking notes, you're welcome to continue doing so, but before you make that decision, be advised you will receive a written version of these instructions. Collin Griffith, the defendant in this case, has been accused of the crimes of first-degree murder and kidnapping. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that Catherine Griffith was killed by Collin Griffith, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was second-degree murder or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I will now instruct you on the circumstances that must be proved before Collin Griffith may be found guilty of first-degree murder or any lesser included crime. Now, there are two ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that the death was caused by the criminal act of Collin Griffith. And third, that there was a premeditated killing of Catherine Griffith. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. However, the period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that while engaged in the commission of kidnapping, Collin Griffith caused the death of Catherine Griffith. And third, that Collin Griffith was the person who actually killed Catherine Griffith. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that Collin Griffith had a premeditated design or intent to kill. To prove the crime of kidnapping, the state must prove the following three elements beyond a reasonable doubt. First, that Collin Griffith forcibly, secretly, or by threat confined, abducted, or imprisoned Catherine Griffith against her will. Second, that Collin Griffith had no lawful authority to do so. And third, that Collin Griffith acted with intent to inflict bodily harm upon or to terrorize Catherine Griffith, or commit or facilitate the commission of any murder. In order to be kidnapping, the confinement, abduction, or imprisonment, A, must not be slight, inconsequential, or merely incidental to the murder. B, must not be of the kind inherent in the nature of the murder. And C, must have some significance independent of the murder, in that it makes the murder substantially easier of commission or substantially lessens the risk of detection. Secretly means the defendant intended to isolate or insulate Catherine Griffith from meaningful contact or meaningful communication with the public. Now, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he's been accused, there may be evidence of other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder, as I've said, are second-degree murder and manslaughter. The lesser crime indicated in the definition of kidnapping is false imprisonment. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that the death was caused by the criminal act of Collin Griffith. And third, that there was an unlawful killing of Catherine Griffith by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, an act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove Collin Griffith had an intent to cause death. To prove the crime of manslaughter as a lesser included crime in count 1, the state must prove the following 2 elements beyond a reasonable doubt. First, that Catherine Griffith is dead. And second, that Collin Griffith intentionally committed an act or acts that caused the death of Catherine Griffith. Now, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is called negligence. Collin Griffith cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that Collin Griffith had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To prove the crime of false imprisonment as a lesser included offense in count 2, the state must prove the following 2 elements beyond a reasonable doubt. First, that Collin Griffith forcibly, secretly, or by threat confined, abducted, imprisoned, or restrained Catherine Griffith against her will. And second, that Collin Griffith had no lawful authority to do so. Again, secretly means Collin Griffith intended to isolate or insulate Catherine Griffith from meaningful contact or meaningful communication with the public. It is a defense to the crime of first-degree murder and all of the lesser included crimes of first-degree murder if the actions of Collin Griffith constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Again, great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Collin Griffith does not have the burden of proving that he was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. Collin Griffith was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself. Collin Griffith had no duty to retreat before using deadly force. If Collin Griffith was in a residence in which he had a right to be, he had no duty to retreat and had the right to stand his ground and use force, including deadly force, if he reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to himself. The use of deadly force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery or aggravated assault upon him. In deciding whether Collin Griffith was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Residence means a dwelling in which a person resides, either temporarily or permanently, or is visiting as an invited guest. However, the use of deadly force is not justified if you find that the defendant was attempting to committing, or escaping after the commission of kidnapping. If you find that Collin Griffith, who, because of prior threats or difficulties with Catherine Griffith, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of Catherine Griffith, you may consider this fact in determining whether the actions of Collin Griffith were those of a reasonable person. If you find that at the time of the alleged first-degree murder or any lesser-included offense, Collin Griffith knew that Catherine Griffith had committed an act or acts of violence, you may consider that fact in determining whether Collin Griffith reasonably believed it was necessary for him to use deadly force. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, and that her reputation was known to Collin Griffith, you may consider this fact in determining whether the actions of Collin Griffith were those of a reasonable person in dealing with an individual of that reputation. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, you may consider this fact in determining whether she was the initial aggressor. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Collin Griffith and Catherine Griffith. Now, if you find that Collin Griffith committed second-degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon or manslaughter with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction. If you find that Collin Griffith committed second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder or manslaughter. The defendant has entered a plea of not guilty. This means you must presume or believe that the defendant is innocent. This presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and that the defendant is the person who committed the crime. The defendant, on the other hand, is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced during the trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or a lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you, as the jury, to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some other things you should consider are as follows. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Now, the fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Also, expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like any other witness, a juror may believe or disbelieve all or any part of an expert witness's testimony. It is entirely proper for a lawyer to speak with a witness about what testimony a witness would give if called to the courtroom or discussing his or her testimony with a lawyer. You may rely upon your own conclusions about the credibility of any witness. As I've said, a juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove guilt by evidence. The defendant exercised a fundamental right by choosing not to become a witness in this case. You must not view this as an admission of guilt, nor be influenced by his decision in any way. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain that it was freely and voluntarily made. If you conclude that the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the total circumstances, including, but not limited to, whether, when the defendant made the statement, he had been threatened to get him to make the statement, and whether anyone had promised him anything to get him to make the statement. If you conclude the defendant's, If you conclude the defendant made the out-of-court statement, but that it was not freely and voluntarily made, you should disregard it. The following are some general rules that will apply to your deliberations, and you must follow these rules in order to return a lawful verdict. First, you must follow the law, as I am now spelling it out for you in deciding your verdict. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the laws in this case. All of us are depending upon you to make a wise and legal decision. This case must only be decided upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And remember, the lawyers are not on trial. Your feelings about them must not influence your decision in any way. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job to determine what an appropriate sentence would be if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. And your verdict must not be influenced by feelings of prejudice, bias, or sympathy. It must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that makes you think I prefer one verdict over the other. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. Now, if you return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree premeditated murder or first-degree felony murder. Remember, the verdict must be unanimous. Each of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. It must be in writing, and for your convenience, the necessary verdict form has been prepared. It is fairly straightforward, but the law requires that I show it to you, explain it, and read it into the record. And this is it. It is 2 pages long. At the top of the first page is what we call the caption. That gives you the information about where the case is pending, who is involved, and so forth. It reads, in the Circuit Court of the 10th Judicial Circuit of Florida in and for Polk County, with the case number 53-2024 CF 8410A000XX, and the division assignment underneath, F9. You'll then note the names of the parties pitted against each other. State of Florida, plaintiff, versus Collin Griffith, defendant. It is entitled, not surprisingly, Verdict. It then begins, and you'll notice count 1 is on page 1. We, the jury, find as follows as to the defendant in this case. As to count 1, you'll notice a parenthetical there which reads, select only one. That's a simple reminder that you can only have one verdict for each count. There are 4 choices underneath, marked A through D, with a line out to the left. That's where you'd place your mark when you've agreed on your verdict. That can be a check, X, 4-person initials, whatever you like, so long as it's clear and singular. Those choices are: A, the defendant is guilty of first-degree murder as charged in the indictment. B, the defendant is guilty of second-degree murder, a lesser-included offense. C, the defendant is guilty of manslaughter, a lesser-included offense. D, the defendant is not guilty. And then at the top of page 2 is count 2. As to count 2, again the reminder to select only one. 3 choices for count 2 marked A through C. A, the defendant is guilty of kidnapping as charged in the indictment. B, the defendant is guilty of false imprisonment, a lesser included offense. C, the defendant is not guilty. Now, if in count 1 you found the defendant guilty of either first-degree murder or second-degree murder, you'll notice this next section called Special Findings. And there's a question, depending on your verdict in count 1, there are 2 potential questions here. But the first question you would only answer if you found the defendant guilty of first-degree murder or second-degree murder. And that question is, 1, did the defendant actually kill Collin Griffith? The reminder again to select only one. These findings also have to be unanimous, and the reasonable doubt standard applies as well to these findings. So, did the defendant actually kill Collin Griffith? 2 choices, yes or no. Then the second question for count 1, and this is if you find the defendant guilty of second-degree murder or manslaughter. And that question is, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a weapon? Again, select only one, yes or no. So, if you find the defendant guilty of first-degree murder, you would only answer question 1. If you find the defendant guilty of second-degree murder, you would answer both questions. If you find the defendant guilty of manslaughter, you would only answer the second question. If you find the defendant not guilty, do not answer either question. It concludes, so say we all, this blank day of February 2025, and then there's a place for the 4-person signature, and underneath to print his or her name. Now, a separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict rendered as to each. Now, a finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged, except, as I'm about to explain to you in the instruction regarding legally interlocking counts. The crime of first-degree felony murder, charged in count 1, is linked to count 2, kidnapping, and that the crime charged in count 2, kidnapping, is an element of the first-degree felony murder charged in count 1. You should first consider the evidence applicable to count 2. If you find that the crime charged in count 2, kidnapping, has not been proven beyond all reasonable doubt, you must find the defendant not guilty of first-degree felony murder in count 1. If, on the other hand, you find that the crime charged in count 2, kidnapping, has been proven beyond a reasonable doubt, you must then consider the evidence applicable to first-degree felony murder charged in count 1. Now, a guilty verdict on count 2, kidnapping, does not require a guilty verdict on the charge of first-degree felony murder in count 1. You should find the defendant guilty on the charge of first-degree felony murder in count 1 only if you find all the elements of the crime, including the essential elements contained in the crime charged in count 2, kidnapping, were proven beyond a reasonable doubt. However, the alternative crime of first-degree premeditated murder in count 1 is not linked to any other count in the indictment. A finding of guilty or not guilty as to count 2 must not affect your verdict as to the first-degree premeditated murder in count 1. In just a few moments, Mr. Hertel will take you to the jury room. The first thing that you should do is select a foreperson who will preside over your deliberations, much like the chair at a meeting. It is that person's main function to see to it that your discussions are carried out in an organized fashion and to make certain that each of you has a fair opportunity to be heard. It is that person's job, as I've said, to sign and date the verdict form when you have agreed on your verdicts, and to bring the verdict form to the courtroom when deliberations have concluded. During deliberations, jurors must communicate only with one another, and only when all jurors are present in the jury room. That means if someone steps into the restroom, all discussions about the case must stop until that person returns. You are not to communicate with anyone outside the jury about this case until you have reached a verdict. Remember, you must not talk about this case in person or through the telephone, in writing, or by use of an electronic device, or by any use of electronic media. Do not contact anyone to assist you during deliberations, and know that these rules will continue to apply until you are discharged at the very end of the case. If you become aware of any violation of these instructions, or any other instruction I have given you during your service, you must tell me by giving a note to the bailiff. Now, many of you have cell phones, perhaps other types of electronic devices with you. The law does not permit those things to go to the jury room with you during deliberations. Mr. Hertel will be collecting those things from you. They will be securely stored away in an evidence closet. No one will have access to them. And they will be returned to you promptly upon your discharge. Or if your deliberations aren't concluded today, you will be given them for the overnight recess. I would ask that you put those things on silent or vibrate. I do have other business to conduct in the courtroom. It would be distracting if your cell phones are ringing over there in the closet. If you need to communicate with me during deliberations, please do that in writing by sending a note through the bailiff. Now, if at the time you send such communication you have taken a vote, please do not disclose the nature of your vote to us. That has nothing to do with any of our functions. It is your private affair. If you have questions, I will have to talk with the lawyers about your questions before I answer, if I'm able to answer. That could take some time. If you are able to continue deliberating while you await my answer, you may certainly do so. If I am able to answer a question and the answer is simple, I will very likely respond in writing on the same piece of paper that you sent to me. If that happens, please keep that piece of paper with the evidence. It must be filed in the court file at the conclusion of the case. If the answer is more complex, you may be brought back into the courtroom for some additional oral instruction. During the trial, several exhibits were received in evidence. You may examine whatever exhibits you think will assist you during your deliberations. They will all be sent back to the jury room with you when you begin to deliberate. In closing, let me remind you, it is important that you follow the law as I have just spelled it out for you in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For centuries, we have agreed to live by the Constitution and the law. No juror has the right to violate the rules that we all share. Any objections to the instructions as orally given or any additional instructions requested by the state?
No, Your Honor.
By the defense?
No, sir.
All right. Before I identify our alternate jurors, which is my least favorite part of the trial, and send you back to deliberate, I want to know if any of you are aware of any violation or if any of you have been exposed to any information, anything that might impact your ability to continue serving fairly and impartially. If something you're supposed to make me aware of has not been brought to my attention, please raise your hand. All right. There are no hands raised. You all know your juror numbers, correct? Juror number 1981288, 1981110, and 1980802, the three ladies on the far end of the back row. You are our alternate jurors. You will not be going back to deliberate. There are a few things I would like to say to you before I discharge you. So if you would stay behind in the courtroom with us, the bailiff will make sure that some lunch is set aside for you to take with you. You're welcome to do that. So if you'd stay behind with us for just a moment, for the rest of you, we will send back the written instructions, the verdict form, and the evidence to you in just a moment. You may now retire to consider your verdict.
All rise, please. Can you bring your notepad?
Ladies, I'm not sure how you feel. Oftentimes the alternate is quite disappointed to find out they've devoted so much of their time to the system and then don't get to do really the most important job of the juror back in the jury room. Many alternates are quite relieved to find out they don't have to go through that process. Wherever you fall on that spectrum, I hope that you understand that you have performed a vital service by being here. Across the nation every day, in state and federal court, in criminal and civil cases alike, alternate jurors are selected, many times more than one, such as in this case, and more often than you might think, the alternate or alternates are called upon to take the seat of someone who is excused for one reason or the other during the case. That is especially true and happens frequently in cases covered by the media. This case has received significant media attention, national media attention, and the danger that a friend or family member spouts something off about what they saw on the news that rings a bell with you, or folks just approaching you, trying to talk to you. The danger is quite real that jurors become prejudiced during the trial. So that's why we have multiple jurors, also the fact that it was over a week-long trial. So I want to make sure that you understand what a vital service you've performed by being here, and here's why it's important. If something had happened to those who are now back there deliberating, and I did not have an alternate or sufficient number of alternates to replace those folks, and the parties could not agree to proceed with fewer jurors than they're entitled to under the law, in this case 12, my hands would have been tied. I would have had no choice but to scrap everything, send everyone on their way, and start all over on another day. And you know just what an expensive proposition that is for everyone involved, your fellow jurors, and the community of taxpayers. So you have indeed performed a vital service. I've been telling you cannot talk about this case or look things up. You are completely released from both of those orders. You can talk to anybody you want to, including the people here. They can't approach you, but if you had questions or comments, you can approach them. You're welcome to stay and see what happens. Want to make sure that you get some lunch, but you are also equally free to forget about this case, refuse to talk to anyone, and be on your way. That's going to be up to you. On behalf of the entire 10th Circuit and all assembled here, I humbly thank you for your service. You are now discharged. I think we need to wait on the bailiff because he's going to take you out this back door, so give us just a moment.
All right, everybody. So I thought, you know what? It's jury deliberation time. Let's continue the discussion from earlier while we await the jury's verdict and talk about what we saw in the defense's closing argument, what we saw then in the follow-up. So obviously, I can see from the poll so far, we've got a rather mixed group here out of the 10 votes. We've got 40% saying guilty, 40% guilty of a lesser, hung jury 20%, and nobody saying not guilty. Now, I want everybody to remember that we are privy to details that jury is not. So there's a lot of bias out here. This is one of those cases where us viewing this outside the courtroom, outside of the measures being taken, totally changes how we interpret the evidence, because our perspective is going to be very much colored by the fact that we know what happened in Missouri. We know this guy did something to his father. But this jury is going to be dealing with knowing that there was another incident. He's never been charged. They're not going to know it was his dad unless they already knew this going in, although these jurors were intensely questioned and vetted. And judging from the defense and the approach they've taken, we have people who are would be very open to self-defense. They're open to the idea of defending themselves. And I think that this could be a surprising verdict for many, because I want you to kind of, if we were looking at this without the knowledge of what happened in Missouri, what happened between him and his father, what are we looking at here? Now, we know there were some statements made, right? We know that allegedly unrecorded statements made to the grandfather, but there's a problem with those. And what is the problem? Well, the problem is he didn't report them to anybody in terms of authorities or police until after she passed away. Now, we know she alluded to these, right? But we know she also made a 2.5-hour drive, even in light of whatever it was her father told her that he said. Now, the father says now what he said, but we don't know because the mom never gets into specifics, nor is there a recording of what it was that this guy allegedly said, that Griffith allegedly said to his grandfather. But here's what we do know. We know that this jury is sitting on a set of facts that this mom was definitely mentally disturbed herself. She had problems. And as I said, the defense jumped right on what I said they would. And that is the fact that she had attacked someone else with a knife. So the question is, when they go into a highly charged, highly volatile situation, and they end up in that house together, is it really reasonable to think that beyond a reasonable doubt that this young man becomes the sole aggressor in this situation? Remember, this woman pursued him. He left. If we were looking at this case in any other light, without any of the back knowledge, we would be saying this young man has been retreating and retreating and retreating. Remember, he was at that house a few days prior. They get into it. What does he do? He leaves and he goes to his grandmother. What does he do in prior incidences? Please get me out of this situation. Now, when he's asked, they say, what would you do if you went back in? He says, eventually I'm going to have to defend myself. He's telling everyone. We're hearing it on the Ring cameras. Now, what we know is that this lady has tried every bit of manipulation that she could to get her son back. And she drives 2.5 hours and goes and confronts him. We know from the neighbors that there's a confrontation going on. She isn't coming in with candy and his favorite junk food and saying, son, come back home and let me make you dinner. She's telling him, get your butt home. And like we already know, she has a history of confrontational, volatile, and violent issues when she's not getting her way. She ran over her ex's girlfriend's or a member of her ex-boyfriend's family. She stabbed the dad that ended up dying in a domestic dispute of the past. We know that she was involved in domestic occurrences. We know that there were allegations that she hit. We know that police came home and saw that she was doing some extremely disturbing punishments for this young man with weights above his head and all these things that were not normal ways that you would handle things. And that this young man was being provoked and pushed to his own extent. Now, does that say that he should have hit his mother or done anything like that? Absolutely not. But he did try. He tried to retreat, and she comes to him. Now, that's where the craziness of this prosecutor is, where he tries to paint this picture that she's got this perfect home with all the amenities and all the things he loves, and all she wants is her son home. Well, we heard the ring camera. We heard the cussing and the berating. And there is, as we talked about on Saturday when I was when I was doing the On the Record podcast with Jody Bolt, and we showed the article, which was referencing the study of the damage that verbal abuse can have on the psyche of young children, and especially when then you couple it with actual physical abuse. And this woman who we already know is
good morning. If we can have Ms. Bluell back
is
on the stand, please.
Hold on one moment here. We already know that this woman is someone who's capable of having violent confrontations, who we know is emotionally unstable. So with that background, and that knowledge, it's not clear cut as the prosecutor would have you believe. It's not this clear cut thing that says, hey, she's just going there out of the goodness of her heart. So where do I think the jury finds in this case without the knowledge? I don't think there's any way they're getting to, in my opinion, the top end of this. I would be very, very surprised if they come in with that. I think they are going to find some form of a lesser charge. I think it's actually going to be manslaughter, because I think what they're going to think is that he went too far. I think they're going to find manslaughter. That there's this confrontation. Nobody knows who picked the knife up first, but it's very hard for me to believe that a jury could get to premeditated or a premeditated act in this case when this lady pursues him. And with the history, now I understand there's the alleged conversation from the grandfather, but if you don't believe him, if there's a question of credibility there, and then you have the other evidence that comes in that shows that this lady had a propensity and had a history of attacking people with knives, and a knife is used, I find it hard to believe that you're going to get to a point where you're going to say, okay, this young man who had did everything up until that moment to try to get away from this woman, and she pursues him, backs him into the corner, takes him into the house. Now, getting to self-defense, I don't know, but it is possible. I could see this jury coming back on self-defense, because if she's attacking him and they think that, and again, I don't know, we weren't seeing the pictures, but if there's any potential way that she's coming at him with the knife and he's going backwards like this, and the positioning of that cut, it's very possible that if they were wrestling around, and remember, he had defensive injuries, he had cuts on his hands. So meaning there's a possibility that she was coming at him and he was defending himself. And in that process, she gets cut on her neck and bleeds out. Obviously, the statements he makes to the grandfather are disturbing. I think that would be a very good outcome because of what we already know to be the case about his history. That if he gets manslaughter, which is punishable by up to 30 years in Florida, that the judge would then be able to dispense a sentence and potentially even ask for him to receive some sort of mental health counseling and supervision when he gets out. Because I think the biggest fear for everyone in this case, if you've been watching it, is that it just seems like if this young man is acquitted and allowed to walk out of that courthouse, it's not a matter of will he, it's a matter of when, it's a matter of if. He will do this again, I think. And that's very scary because, and it may be the grandmother, or it could be a future spouse. But clearly, this young man has shown twice now that he's capable of doing this. And the other thing is he can't just walk away without getting, obviously, without getting some form of mental health. Now, the problem is with a straight not guilty, there's no requirement that he gets any mental health help because they're not asking for a not guilty by reason of insanity. They're not raising a mental health defense. So it's very, very scary for the residents of where this young man might live. The thought that he'll be walking around having already killed 2 people. Now, again, I have a strong suspicion that if he were to be acquitted, that the authorities in Missouri may move on him. I don't know. But I just feel like maybe there's some things that were found. Maybe there are some tapes. I don't know. Maybe there's some statements that have since been given that the Missouri authorities would say, you know what, rather than let this kid walk around, we're go ahead and arrest him and take him to Missouri and put him on trial over there and see if we can get a conviction over there. And it's just another opportunity for them to try to keep the community safe from a young man who's very troubled, who's had very troubling relationships with his parents, who's definitely not been in loving relationships. Sorry about that, guys. I'm actually starting another stream while I'm doing this, so that's why there's the background. But who's not been in loving relationships and it is extremely dangerous. I mean, extremely dangerous. So I don't know. I think this is going to be one of those situations, kind of like when I served on the jury, where you get out and you find out about the person that you served on, but you have to understand that they're not here to talk about the dad, and that really can't come in if the judge decides it's not relevant, and that would create bias. On the jury that I served on, the defendant that I was involved in had been previously convicted of crimes against young kids that I didn't even know about. But when I looked up the defendant and was doing research, like I'm sure many jurors do, I realized, holy cow, this guy had a history of this stuff. Now, but the crime he was charged with had nothing to do with that. So it would have been extremely inappropriate had I gone home and done research and not followed what the court would have told me to do, and then found out about that. Could that have colored my opinion of this man? Could that have colored my verdict? Could that have colored what I would have said if I would have thought to myself, you know what, this guy could be a danger to the community in other ways, and we have an opportunity here. And in that case, it was a self-defense case with 2 relatives. Could that have colored my opinion of his actions and who he was? Of course. Would I have let that happen? I don't think I would have. But when I came out, I thought, oh my gosh. And for a minute, I thought to myself, did I make the right decision? But I know I did, because I judged that case when I was deciding as a juror on the facts and the merits and the evidence that was presented to me at that time. So we'll see. We'll see what happens. We'll see if what this jury comes up with, because I think it's going to be very, 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 very interesting. So with that said, guys, I just want to come in, finish up my thoughts from earlier, give some reflections on what I thought of the state's closing and the defense's closing, followed up by the state's closing. The state, I'm disappointed in the way the prosecutors, and I'm disappointed in general with ASAP Rocky prosecutors. I'm so disappointed in them, because they're doing what, and so is this guy. They're so caught up in the wrong thing. They're not here to win. They're here to look at the evidence and figure out the best outcome. And that this prosecutor could sit here and look and say that this is premeditated, this is some premeditated act, like he planned it out, I think is really disingenuous. This prosecutor would have been better off charging this case the way it needed to be charged. And in my opinion, that would have been some form of no worse than second degree. Because this is something that developed in the moment. There's a strong likelihood that this woman picked up the knife and maybe introduced the knife. And maybe at that point he lost control. But to go the route of kidnapping and holding against her will, and I understand his theory is that she was in there for an hour. I don't think that they were in there. I don't think she was dead for the entire hour. I think that they were in there for the hour. I think there was it got highly charged, and there definitely was obviously an altercation, but it obviously wasn't some situation where he's dragging her all around and there's this great resistance, because the trailer itself was in pretty good condition. It wasn't signs of a major struggle. So that's problematic for the way we're looking at this. But I think what's clear to me is that that there's no way to rule out here that this woman didn't pick the knife up and come at him. He had defensive wounds. So I think, to me, this would have been a better way, is to offer this young man manslaughter, right? Manslaughter, with the ability for him to get some mental health help and hopefully deal with the demons that are inside of him. But at the same point, acknowledge that this mother was not a saint. And by acknowledging that, also acknowledging the failings of the people around this child, who ignored his pleas to go into foster homes, who ignored his pleas to have the mom. Hold on one moment, guys. All right. Anyway, sorry about that, guys. I have a request there I have to fulfill here in a few moments. So, but who ignored him, and that's where this prosecutor, by putting this all on the mom and making her seem like she is this terrible individual, that she is this saint-like individual who created a perfect home, and that he's this premeditated kid, or he's this premeditated unaliver who's just evil, and decides out of a place of evilness to unalive her, takes away from the reality of the situation. And the reality of the situation is that this situation was on a collision course. You had a mother who was unstable, who was unfit, that they failed to take this child out of her care. You had a kid who's already done this once, and they're leaving him in a volatile situation. And it was basically just who was going to kill each other first. And the likely outcome was what exactly occurred. She was going to do something that was going to provoke, because we know she's done it before. She's pulled knives. She's ran people over with cars. She's tried to kill herself. And she was going to eventually do something that was going to cause him to do something that was going to put the situation in where it's at right now. So the state, in my opinion, is doing a disservice to allowing this situation to not happen again, to allowing the proper reflection and the proper analysis of where these entities went wrong in where they could have prevented this from happening. And that's where a complete conviction for the top charge robs us of that. Now, if the jury comes back, and I believe finds what they should do, which is finding some form of a lesser, which acknowledges the fact that the mom came into this situation and was caused a part of it. Now, she didn't deserve to die, but she caused her coming to the house was not what should have happened. She should have followed the advice of that detective Rabioni. She should have stayed away, and she should have let things cool down, but she wasn't going to do that. And all of these people that were involved in this case, like they have been, they're to blame, and they should be held accountable to some level as well. Not necessarily criminally, but they should be looked at as saying, what could you have done different? How could you have acted differently? And how should this have gone different? And it should be, and those discussions don't happen if they're allowed to claim that this was a result of an evil kid who just had evil intentions, who just wanted to come in and kill his mother. And it's not that simple. I don't believe it's that simple. But I do believe it's a very scary thought of just unleashing him back on society in a few hours if this jury comes back with a full not guilty. That's a very, very scary situation. I believe we'll be covering another case of his in the very, very, very near future. But anyways, with that said, guys, we're going to await the jury's verdict. And of course, as always, we'll be here waiting for it, and we'll deliver it to you. And of course, I will absolutely give you my thoughts with what the jury comes back with. We've got the closing arguments. If you missed some of the closing arguments, they're going to be released in their own individual videos over the next couple of hours. So is the judge's instructions. I'd encourage all of you to watch closely the judge's instructions. There's going to be, once the premieres are done, key timestamps will be present in those videos for you to go to the important parts. Even if you've already seen them and you want to see what the important parts are, jump in and check them out. It's going to be important for you to understand what this jury comes back with as you're deliberating on this as well. And of course, take another listen. Listen to what the defense says. Listen to what the state says. Go back. The full playlist of all the testimony in the case is complete with timestamps to key parts of those testimonies. So if you want to go back and review, I would encourage you to go back and review Detective Rabioni's testimony. If I'm saying that right, I don't know if I am, because she holds, I think, what will be very compelling evidence that these jurors might rely on. Review that grandfather's testimony. Let me know whether you think he's credible or not. Would you believe him? Do you believe him? Do you think he's credible in what he said? Or do you think he's making stuff up to insert himself in this case? Or do you think he's maybe exaggerating a little bit, which is where I think he's at? And he may have said something like that. Like, I think he said something to the degree of, like, at some point I'm going to kill my mom. Like, I'm going to kill her if she does this, or if she comes at me with a knife. Remember, the whole family's aware of what she does. So some of these statements could have been said in a different context, but then when she dies, everything's taken much different. But anyways, check it out. Let me know. And we're going to throw it back here to the courtroom for deliberations, and we'll see what happens.
present with Ms. Thornhill and Mr. Hendry. Mr. Levine is here for the state. The jury has a request. It's been reduced to writing. It's dated 2/4/25. It reads, Judge Abdoni, we are requesting court transcript from Susan Detman's neighbors, Sally Bell and Nancy Jones. Sincerely, Juror 1980896. Mr. Levine?
I'm amenable to any request, Your Honor.
Ms. Thornhill?
Well, Judge, we're not real time, and I don't believe that a transcript is available for that. I could be wrong.
Well, I don't think we provide transcripts because it's required to be done in open court. All I can do is permit a readback or a playback, but I don't think there's a recording. So, is that correct, Madam Court Reporter? No playback? All right. So, the bar has recommended certain instructions in this instance. First, the standard instruction directs or suggests they be told that transcripts are not available, but that they may have testimony read back to them. And then I can combine that with the instruction that talks about how long it's going to take the court reporter to prepare it for readback, and then tell them to discuss their request further. And if they're not able to resolve their question about the requested testimony by relying on their collective memory, they should write down as specific as a description as possible of the part of the witness's testimony they want to hear. So I can do that, or I can say no. Just flat out no. So, Mr. Levine?
I'm fine with either one, Your Honor.
Judge, if I could have a moment to
All right.
discuss.
Hate to say no, because there's obviously something they cannot collectively remember, but
Judge,
you have the look of, you want me to say no on your face.
I do. I should not play poker with you.
No. Well, I should not play poker with anyone because I'm not very good at it.
I hear that because I also am bad at that. At any rate, at this point, I think because it's such a general request, if you tell them that transcripts are not available and leave it at that, and then if they come back on their own with a more specific request, maybe we can entertain the idea of asking them if they, letting them know it would take a while to have a readback done, and if they can narrow down their request further, that would be helpful. So basically, baby steps. Start with no transcripts are available. Please rely on your collective memories.
Mr. Levine?
Could you please read their question one more time?
We are requesting, I think that says court, we are requesting court transcript from Susan Detman's neighbors, Sally Bell and Nancy Jones.
Your Honor, I'm fine with the court doing whatever you feel is appropriate under the circumstances.
Is there some prejudice to taking two baby steps first and saying transcripts are not available? A readback may be possible, but we will need you to be more specific regarding your request or the portions.
How about 2.5 baby steps then? If you're not willing to tell them just no transcripts are available, please rely on your collective memories. Then add the step of a readback may be possible if you can narrow your request further. Just so that they don't come back and say we want all the testimony of both witnesses read, because that I think is a problem, because then we could get into having a readback of every witness's testimony.
All right, so let me cobble something together out of these various instructions. How long, well, whether they, no matter what they want?
They were short,
Okay.
right?
Yes, they were
They
fairly
weren't
short.
the longest witnesses in the world, but they also weren't the shortest. Judge, as I'm saying it out loud and as I'm writing it down, I'm thinking though, if we ask them to narrow their request, then that might risk the possibility of highlighting a certain piece of testimony over any other piece of testimony. So I go back to my original request of just saying that no transcripts are available.
Mr. Levine?
If we're gonna say there are no transcripts available, I think it should be included, but a readback may be possible.
Any response?
I'm thinking, it's like I said, it obviously would be helpful to know if there's a particular area that they are asking for a readback on. But then, like I said, that could highlight one portion of one witness's testimony, and they may miss some other part of their testimony if we just have a partial readback. But on the other hand, they're asking for both witnesses' transcripts of all their testimony. That tells me they're sort of fishing for something, which I don't think is appropriate for a readback.
So I'm not sure which.
So at this point, I think I'd rather you just say there are no transcripts available and leave the ball in their court as far as what they want to do beyond that. Usually in this circuit, the judges err on the side of not over-explaining, not over-offering. So I think that might be the best way to approach it.
All right, well, the instruction suggests that I can be somewhat generous in my response, but ask them to be as specific as they can. So I intend to advise them transcripts are not available, to discuss their request. If they can't resolve it with their collective memory, then they may request to have testimony read back to them, and that if they decide to make such a request, it should be as specific as possible.
That's acceptable to the state, Your Honor.
And over your objection,
Yes.
that's how they will be instructed. So let me just finish here. All right, so my intention is to advise the members of the jury you have asked that transcripts of testimony be provided for you. Transcripts are not available. However, a readback of testimony may be granted at the court's discretion. I now direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you may request to have testimony read back to you. If you decide to make such a request, it should be as specific as possible. All right. We're ready. Members of the jury, you have asked that transcripts of certain testimony be provided for you. Transcripts are not available. However, a readback of testimony may be granted in the court's discretion. I'm going to instruct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you may request to have testimony read back to you. Again, that would be granted in my discretion, if at all. Now, if you decide to make such a request, it should be as specific as possible. You may now continue with your deliberations.
All rise, please.
I will also tell you, I don't know who told Mr. Hertel, but the jury verbally told him they want to end at 4:30 today. I did not ask him to have them put that in writing because they might change their mind. They know to tell him they want to go home for the evening, so I just left it at that. Any objection to that, Mr. Levine?
No, Your
No, sir.
All right. Don't go far.
Yeah.
be seated. The jury informed the bailiff they want to recess for the evening. I'm just going to give them some reminders. Please be seated. All right, ladies and gentlemen, I've been advised that you wish to retire for the evening and come back tomorrow to continue deliberations. I'm going to grant that request. I've told you this part of the trial, the schedule is in your hands. Just those same reminders. Please don't talk to anyone about this case or let anyone say anything to you. The folks you are closest to may know that you're now deliberating, and they're going to be very tempted to ask you questions, although I am certain that you've informed them how important it is they not do that. But if they do, just tell them you're still under that strict order, and if you want to, you can talk to them as much as they want to talk to you about it when the trial is over. Please remember not to look anything up. Please remember to avoid those parts of the news that I've told you not to expose yourself to. And I hope that you have a restful evening. Please report back tomorrow morning at 8:30.
All rise, please.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud.